Yes, Anil bhai.
Yes, good afternoon.
Good afternoon. Vishwas. શાંતિલાલ અને સુનિલભાઈને આસિસ્ટન્સ કરી એમને પેનલિસ્ટ તરીકે એડ કરાવડાવો ને ઈમેલ લિંકમાંથી.
હા
હા, કારણ કે એ ટોપિક મોટો હતો ક્રિમિનલ અપીલ્સ નો, એટલે then we could not take queries.
Yes, Anilભાઈ.
Yes, good afternoon. Good afternoon, Sam. Ashutosh.
Vishwas. શાંતિલાલ, સુનિલભાઈ. આસિસ્ટન્સ કરી એમને પેનલિસ્ટ તરીકે એડ કરાવડાવો. ઈમેલ લિંકમાંથી.
ટોપિક મોટો હતો.
Parth, can you hear me? Yes. આશુતોષ,
હા ધ્રુવેન,
કાર્તિકભાઈને લિંકમાં લઈ આવો ને, ઈમેલ લિંકમાંથી એમને લોગિન કરાવડાવો.
હા કરાવડો છે.
Yes,
ફોન
આશુતોષ.
નથી ઉપાડતો ધ્રુવેન, ફોન નથી ઉપાડતો.
ऊपर है बेटा, यहाँ ऊपर है ना दिख रहा.
Sorry, good afternoon everyone.
Yeah, good afternoon. Okay, we have with us Sunil bhai. Welcome,
Yes,
Sunil
sir.
sir.
Hello. Yes, sir.
Welcome, sir.
Thank you very much. All of you.
જી અનિલભાઈ.
હા, કાલ થોડી સિચ્યુએશન બદલે કે કંઈ પણ કરશે તો ચહેરા પર લાઈટ આવી જશે.
અમને એમ તમારું લોગિન થઈ ગયું તો ન ચાલે.
Happy to share with you that we are also live today on the YouTube.
ધ્રુવેન યુટ્યુબ ની લિંક શેર કરી છે આપણે કોઈ જગ્યાએ?
ફ્રેન્ડ્સ ગ્રુપમાં છે, મેં બધી જગ્યાએ મૂકી દો તમે.
ઓકે.
ચાલશે, આપણે થોડી 5 મિનિટ ઉપર મારું પેલું મારે
ચાલુ કર્યું.
યસ, શાંતિલાલભાઈ.
ઓપ્શન આપી દીધું આનો ગાડી ઓપ્શન આપવો પડે. હું તો ઉતાવળ્યું બધી વાતમાં. હા તો 5 મિનિટે નથી થઈ.
વેલકમ શાંતિલાલ.
Yes,
કેમ છો?
પ્રમુખશ્રી. બસ well, ready for hearing.
યસ, આપણી સાથે અનિલભાઈ શાહ, સુનિલભાઈ તેમજ બધા જ રિજિયનના વાઇસ પ્રેસિડેન્ટ જોડાયેલા છે.
Thank you. Nice.
ઓલ ગુજરાત ફેડરેશન ઓફ ટેક્સ કન્સલ્ટન્ટના સંયુક્ત ઉપક્રમે ઇન્કમ ટેક્સ બાર એસોસિએશન અમદાવાદ, નોર્થ ગુજરાત ટેક્સ પ્રેક્ટિશનર એસોસિએશન, ટેક્સેશન એડવાઇઝર એસોસિએશન ગોધરા પંચમહાલ, સધન ગુજરાત ટેક્સ બાર એસોસિએશન સુરત, and the Chamber of Parth Contractor and other association of the state of Gujarat have jointly organized this webinar series. Today, I warmly welcome to all the panelists. Today's subject is very important and very burning issue nowadays, because we heard that there is arrest and prosecutions in the tax matter nowadays, in a taxation matter as well as in the GST matter. So we have with us today's eminent senior advocate S.V. Raju sir is expected in 5 or 10 minutes with us. I also acknowledge the wholehearted support of Advocate Parth Contractor for the untiring efforts and making this webinar series a very historical and it's a unique manner. And this is only possible just because of the help of the Chamber of Parth Contractor. We express our gratitude to the Parth Contractor and all the panelists here. We have with us Mr. Anil Kesa is the president of the Southern Gujarat Tax Bar Association. We have with us Mr. Sunil Shah is the past president of the Taxation Advisor Association and the very active persons in our Central Gujarat region. Mr. Santilal Thakkar is also the past president of the North Gujarat Tax Practitioner Association and the vice president of the All Gujarat Federation of Tax Association. We express our gratitude to Santilal Thakkar, Sri Sunil Bhai, and then Anil Bhai for such like making this event a very huge, because every webinar we have more than 500 participants. And today also there is a YouTube, more than 200 participants have joined, and in every day we are trying to cope up all the members, one regions or another region, and today we have all the regions of the state of the Gujarat and all Gujarat Federation of Tax Consultants jointly with all the association have organized this webinar. I request Anil Bhai sir to say welcome on behalf of all the association.
I, Anil Shah, welcome all the Vice President of the All Gujarat Federation of Tax Consultant, our active and very smiling President Sri Dhruven Shah, Vishwesh Shah, President ITBA, and all the panelists in this session. I also welcome our learned speaker Sri V. Raju, and I hope that you will really gain something from this webinar, and this webinar will be cherished for years to come.
Okay.
Thank you.
Right. Ready.
Thank you, sir.
Okay. Now I'll start first with the Income Tax Act, then I'll go.
We have with us Senior Advocate S.V. Raju sir. Sir, we warm welcome to on behalf of the All Gujarat Federation of Tax Consultant, Income Tax Bar Association, and various other associations. More than 16 associations have joined today on webinar. Thank you for accepting our invitations for such webinar on the wonderful subject of the arrest and prosecutions in tax matter, especially in the income tax and GST and the legal remedies. Sir, we are very lucky and fortunate to have you with us with this webinar, and we also express our gratitude to S.V. Raju sir, the Senior Advocate. Sir has given a significant contributions in the all the very landmark judgment in as well as in the Gujarat High Court or the Supreme Court of India. I request Parth Contractor to proceed further on this webinar.
Thank you very much, Dhruven bhai. A very warm welcome to Shri S.V. Raju Sahib, Senior Advocate. Thank you, sir, so much for sparing time for all of us. A welcome also to all the office bearers of all the associations, and a very warm welcome to all the participants we have with us. We shall begin with the webinar, sir. Over to you.
Thank you, Parth. It is
Yes, sir.
nice. It is nice to interact with you guys. The topic which you have given to me, I hope I'll be able to cover it in this short span of time. I will start first with the Income Tax Act and the prosecutions and offences under the IT Act. If you look at the screen, at the first slide, you will see the chapter 22 of the IT Act containing sections 275A to 280D deal with these topics or this topic. If you further see the sections in detail, the punishment ranges generally from 1 year to 7 years. The quantum of punishment is relevant, therefore I mentioned the punishment. Now, if the next slide, you will see, next 2 or 3 slides, you will see various offences which are there from 275A onwards. You will also see the punishment. RI stands for rigorous imprisonment. It is from 0 to 2 years. Fine. NC means non-cognizable. B means bailable. NB means non-bailable. Summons case or warrant case is there, and it is triable by special court. Special court in Gujarat is the Additional Chief Metropolitan Court as far as Ahmedabad is concerned. Kindly go to the next slide, please. So these are all the sections. Now you will see all these sections where you will see the punishment ranging from 7 years. You'll see the maximum punishment is 7 years, 2 years, etc. 7 years. Go to the next slide, please. Okay, now the general principle of criminal law is that if there is any offense, whether it is an IPC offense or a non-IPC offense like the Income Tax Act, the procedure of investigation, inquiry and trial is generally governed by the CRPC, unless there is an exception which is carved out in the statute itself, like the Income Tax Act. If it makes out an exception, then those provisions of the CRPC will not apply. Now, these provisions that CRPC applies or not is found in sections 4 and section 5 of the CRPC. Like, kindly go to the next slide. See, if you look at section 4, it says first part deals with trial of offences under the IPC with which you are not concerned for the time being. The second subsection, all offences under any other law, which includes income tax offences, shall be investigated, inquired into, and tried or otherwise dealt with according to the Criminal Procedure Code, but subject to any enactment for the time being enforced, regulating the manner or place of investigating, etc. So generally, the CRPC will apply for all the income tax offences unless there is an exception carved out in the Act itself. Similar is the section, that is the next section, section 5, which says that nothing contained in this code shall, in the absence of a specific provision to the contrary, affect any special or local law. The Income Tax Act is a special law. So if anything is provided in the Income Tax Act, that will overrule the CRPC. Now, what is it, or is there any provision which is contrary to the CRPC in the Income Tax Act? That you will find in section 278A. Kindly go back to the go back one more. Yes, no, go back one slide. Go back one slide, please. Go back one more slide. Yes, no, that was the slide. You missed it. Yes. Now 279 of the IPC of the Income Tax Act. If you look at section 279 of the Income Tax Act, kindly have a look at section 279 of the Income Tax Act. That you will find which says, just give me a minute. I'm sorry, it is not 279. It says all the offences, 279 capital A, sorry, there's a mistake here in the slide. It should be 279 capital A. It says all, kindly come to section 279 capital A. Now 279 capital A says that notwithstanding anything contained in the Code of Criminal Procedure 1973, offences punishable under 276B, 276C, 276CC, 277 and 278 of the Income Tax Act shall be deemed to be non-cognizable. So all these offences, if you look at the chart, are punishable with 7 years of imprisonment. Go back. So it says, kindly look at the offences which is dealt with. One is 276B. Go up one slide. Yes, one more slide. Now 276B, the maximum is 7 years. The next is 276C. There also the maximum is 7 years imprisonment. Then go to the next slide, 276CC. There also the maximum is 7 years. Now go to 277. 277, the maximum again is 7 years. And 278, the maximum again is 7 years. So all these offences are deemed to be non-cognizable offences. Now, what does it mean? What does this mean? If they are non-cognizable offences, what does it mean? Now, go back to the next slide, where it defines section 2, where it defines cognizable and non-cognizable offences. Not this, the next slide, please. Yes. See, cognizable offence means an offence for which, and cognizable case means a case in which the police officer may, for the time being enforce, arrest without warrant. So police officer can arrest without a warrant if it's a cognizable case. But in a non-cognizable case, he can't do so. If he wants to arrest the person, he has to get a warrant from the court. Second thing is that if it is a non-cognizable case, he cannot register an FIR. An FIR can be registered only if a cognizable offense is disclosed. So he doesn't have the power to investigate. He doesn't have the power to register an FIR. He doesn't have the power to arrest. That you will find in section 154, which is the next slide. Kindly have a look at the next slide, please. Yes. So 154, which is a section which deals with the registration of FIR, says that every information relating to the commission of a cognizable offense, if given orally to an officer in charge of the police station, shall be reduced to writing by him. So this deals, section 154 deals with an FIR. So only a cognizable offense, an FIR can be registered. And if it's a cognizable offense, he can investigate, he can arrest. But since all these offenses, by virtue of the statutory provision of ITC, Income Tax Act, have been made non-cognizable, and FIR cannot be registered for these offenses. There is one exception. I'll come to that exception a little later. So all these offenses are non-cognizable offenses. Now kindly have a look at if these offenses are non-cognizable. It means that there can't be an FIR. It means that police can't investigate without the order of a magistrate. So they have to get an order of the magistrate to investigate a non-cognizable offense. That order can be obtained under section 155 of the CRPC. Now 155 of the CRPC deals with the particular case where if the offense is a non-cognizable case and the police want to investigate that case, then they have to get the permission of the magistrate. And the magistrate gives permission under section 155. See subsection 2. No police officer shall investigate a non-cognizable case without the order of magistrate having power to try such case or commit the case for trial. So if he wants to investigate such an offense, he has to apply to the magistrate, and the competent magistrate will pass an order authorizing him to arrest. But even after that order is passed, and even after subsequent to that order, if he starts investigation, he can't arrest. That is what subsection 3 says. Any police officer receiving such order may exercise the same powers in respect of an investigation, except the power to arrest without warrant. So if he wants to arrest, he has to arrest only after obtaining a warrant from the court, which is not the case in case of cognizable offenses. So this is the main distinction between a cognizable offense and a non-cognizable offense. Now, if you go further, kindly look at 279A again. Now, if you look at 279A again, you will find that section 276B is missing. Now, 276B, therefore, of the Income Tax Act, therefore, is a cognizable offense because it is punishable with 7 years imprisonment. Because the code, that is the Income Tax Act, does not make it non-cognizable. Now, 276B is failure to pay tax collected at source. So the dangerous section is 276B, which says if a person fails to pay to the credit of the central government the tax collected by him as required in the provisions of section 206C, he shall be punishable with regular imprisonment for a term which shall not be less than 3 months, but which may extend to 7 years and with fine. So 276B is a section which is a cognizable section for which an FIR can possibly be registered. So you have to be careful if the offense committed is 276B. Now kindly come back to the earlier slide where the schedule to the CRPC is there, where I put it in the, go back. Yes, this is the one. Now schedule to the CRPC tells you what offences are cognizable and what offences are non-cognizable, and what offences are bailable and what offences are not bailable, and which court tries the offence. This is the general law. The first part of this schedule deals with IPC offences. The second part deals with non-IPC offences, which would include the Income Tax Act. Now, for 276BB, the Income Tax Act does not carve out a different role. It only doesn't say anything. Therefore, CRPC will apply. Now, look at this second row. If punishable with imprisonment for 3 years up and upwards, but not more than 7 years. So 276BB will fall in the second row. It is cognizable, it is non-bailable, and it is triable by the magistrate of the first class, but in this case, the special court as constituted under the Income Tax Act. Therefore, if the offense is 276BB, it will be a cognizable offense and it will be a non-bailable offense. So this offense, if it is there, you have to be careful. You may have to apply for anticipatory bail. You may have to take other measures unlike the other offenses under the IT Act. Now kindly come back to the next slide. Now what happens? No, next one, please. What happens if the offense is a non-cognizable offense? If the offense is a non-cognizable offense, then there is no FIR. If there is no FIR, how does the case proceed? The case proceeds upon filing of a complaint. The complaint is required to be filed by the department in the special court alleging that such and such an offense under the Income Tax Act has been made out, which is a non-cognizable offense. On receipt of that complaint, ordinarily the magistrate issues summons. Kindly go to the next case. Next one, please. Yes. So when the magistrate issues summons in a case on a complaint by the department, what happens? Then the summons is received by you and you have to go to the court and appear before the court, which is known as a date for appearance pursuant to a summons. So when you appear before the court, in other high courts, other magistrate courts, other than the courts in Gujarat, bail is required to be taken. But in Gujarat, when a summons is issued, bail is generally not taken. No court in Gujarat ordinarily takes bail when it issues summons for the appearance of the accused. Now, after this summons is issued, what is the remedy available to you? The easiest remedy is to face the trial. But if you don't want to face the trial, what is the remedy? Supposing you want to short circuit the trial, what is the remedy? You have several remedies. The first remedy is you can move the High Court for quashing of the complaint under section 482 of the CRPC or under article 226 of the Constitution. You can choose either 226 of the Constitution and file a petition, or make an application under 482 of the CRPC. Whether you do it under 482 or 226, it does not make a difference. So that is your first remedy. What grounds you can take when you move a petition under 482, we'll discuss some of the grounds little later. Now, the second remedy available to you is you can move the Sessions Court by filing a revision application under section 397, read with section 401 of the CRPC. Now, when you file an application before the Sessions Court, you are challenging the order issuing the process. What is the meaning of the word order issuing process? When a complaint is filed before a court, the court can either issue a summons, or it can issue a bailable warrant, or it can issue a non-bailable warrant. So this order issuing summons, bailable warrant, or non-bailable warrant asking the accused to remain present is known as process, order issuing process. So you can challenge the order of the magistrate or the special court before the Sessions Court and say that this order issuing process, order issuing summons is bad for ABC grounds. What are those grounds? Which will be similar to the grounds available to you when you move an application for under 482 of the Criminal Procedure Code. The third remedy is that you can move for discharge under section 245 of the Criminal Procedure Code. Now, since it's a warrant triable case, you can move for discharge. Then there are two types of warrant triable cases. One is a warrant triable case based on a police charge sheet, which is subsequent to the FIR. Since in this case there is no FIR, therefore there is no charge sheet. The second case is the complaint. So in a private complaint, even though the department files the complaint, it is known as a private complaint. You can move for discharge in such cases under 245 of the CRPC. What are the grounds you can take for discharge? We'll discuss a little later. Earlier, because of one Supreme Court judgment which was overruled, that is K. M. Matthews' case, people used to move for recalling the order issuing process. But now the Supreme Court has said in Adalat Prasad's case, as well as in Subramanian Seturaman's case and others, that you can't apply to the magistrate and ask him to recall the order because the magistrate has no power to review his own order. So you have essentially to move the higher court, that is the Sessions Court, or the High Court under these three remedies, which or you can move the same magistrate for discharge. Now, as far as discharge is concerned, I must tell you one more thing. Now, unlike discharge in a police case filed on a charge sheet, or unlike a discharge in a Sessions case, here the discharge application will be heard after the evidence is recorded. Now, in a case filed on a private complaint, like the income tax complaint, the complainant is generally required to be examined twice if the accused is not discharged. Once he is examined for the purpose of whether there is a case for framing charge or not. So you get the right to cross-examine, supposing there's an income tax officer who has filed the case against you, complaint. He comes into the box at the initial stage, and you cross-examining him first to make out a case of discharge and then argue for discharge. If you do not succeed in discharge, then he will come again and you can cross-examine him again, and then you can try for acquittal. We are not concerned with acquittal at this stage. Now come to the next slide, please. Now, what can be the grounds raised in your petition? Whether it is a petition under 482 of the CRPC, or whether it is a revision application under section 397 of the CRPC, or even if it is a discharge application before the magistrate. The first and foremost ground is that no offense is made out. What do you mean by no offense is made out? When you say no offense is made out, you say that read the complaint, read the averments in the complaint, read what is stated in the complaint. And even if you read what is stated in the complaint, no offense is made out. Therefore, kindly quash the complaint. So generally complaints are quashed under 482 if the offense is not made out. That is one. Second, supposing the offense is made out, then you can still argue that offense is not made out against this particular petitioner or this particular applicant. There may be an offense committed, but as look at me, I have not committed this offense. In that case also, with respect to the petitioner or with respect to the person who has gone to the court can say, yes, offense is made out, but offense is not made out against this particular person. Therefore, I quash the complaint partially. I quash the order partially. And as far as the other accused is concerned, the complaint may go. But as far as this accused is concerned, there is no case made out. Therefore, the case is partially quashed. Then the third is that subsequent favorable orders in appeal or before tribunal or high court in assessment proceedings. The fourth is vicarious liability not made out. And fifth is CRPC section 202 has not been complied with respect. This is with respect to persons who are staying outside the jurisdiction of the court. Kindly go to the next slide. The next is you can compound the offense under section 279(2) of the IT Act, in which case the complaint goes. And the last is that there is invalid sanction or there is no sanction under 279 of the IT Act. Because IT Act requires sanction before a complaint can be filed. Kindly come to the next slide, please. Now this is regarding sanction. Now kindly look at 279. What does it say? A person shall not be proceeded against for an offense punishable under so and so, so and so, so and so section, except with the previous sanction of the principal commissioner or commissioner appeals or the appropriate authority. Now you can argue that there is no sanction. Ordinary sanction is there, but you can still argue. If there's no sanction, you can still argue. You can also say the sanction is not by the competent authority, therefore complaint is not maintainable. Therefore, on this ground, you can get an order of quashing if you succeed. Please come to the next slide. Then kindly have a look at subsequent order. This is 279(1)(a). Supposing the complaint is filed, and then ultimately it is found that the basis of the complaint is not there because subsequent orders either in appeal or before the tribunal or in the high court, the basis for the complaint has been whitewashed or has been removed because the order which you are said to have flouted, that order has been set aside by a competent court or by a competent authority. So section 279(1)(a) says, a person shall not be proceeded against for an offense under section so and so, so and so in relation to an assessment for an assessment year in respect of which penalty imposed or imposable on him under section so and so, so and so, so and so has been reduced or waived by an order under 273(a). So this goes to the extent that even if the penalty is reduced or waived, then certain types of offenses, certain types of complaints go home. And you can therefore raise this point before the magistrate of a discharge or even a quashing petition or even in a revision application before the sessions court saying that, sir, in view of section 279(1)(a), the complaint has to go because I cannot be proceeded because subsequently the penalty has been waived or reduced. But there have been instances. Kindly come to the next slide. Yes, before this, there have been instances where what has happened is, supposing there has been a complaint filed because of certain assessment proceedings. Now, if those assessment proceedings which are not favorable to the assessee are set aside in appeal by the chief commissioner or set aside by the tribunal, then the entire basis goes. So many courts have held that if the basis of the complaint goes, then the complaint has to be quashed. Then kindly have a look at section 2. Go back, please. say under subsection 2 of section 279, any offense under the chapter which I had referred to may either before or after institution of the proceeding be compounded by the principal chief commissioner or chief commissioner or principal director general or director general. So if you apply for compounding you have to make an application before the competent authority. This can be done either before or after the institution of proceedings. And you apply for compounding, then the compounding authority may allow your application by asking you to pay penalty, fine, interest, whatever it is. And your application is allowed and the offense is compounded, then also the complaint gets quashed because of it's not exactly quashed, but it gets compounded, therefore it ceases to exist. Now come to the next slide, please. Now, before I go to this, I want to go to section 202 of this CRPC. Go to the next slide, please. Next slide. Or you come back to the KC Builders slide, please. Yes. Now, this in KC Builders versus CIT 2004 2 SCC 731. This is what the Supreme Court said in paragraph 26. In our view, once the finding of concealment and subsequent level of penalties under section 271(1)(c) of the Act has been struck down by the tribunal, the assessing officer had no other alternative except to correct his order under section 154 of the Act as per the direction of the tribunal, as already noticed. The subject matter of the complaint with the court is concealment of income arrived at on the basis of finding of the assessing officer. If the tribunal has set aside the order of the concealment and penalties, there is no concealment in the eye of law, and therefore the prosecution cannot be proceeded with by the complainant, and further proceedings will be illegal and without jurisdiction. So this is what I had said, that if subsequent orders overrules the assessment order, then the complaint also goes home. Now come back to section 202 of the CRPC. See, 202 of the CRPC is a section which says that the magistrate can do certain things. Now, what can the magistrate do if a complaint is filed? There are usually 4 or 5 things which he can do. He can dismiss the complaint under section 203. Ordinarily, complaints filed by the department are not dismissed. He can order an inquiry under 202 of the CRPC. Inquiry is required if the magistrate feels, yes, I want to know whether the offense is actually, I feel that the offense is committed, but I want to go into details, find out. Therefore, he may inquire before issuing process. The third is he may be satisfied and he can say, yes, offense is made out. Therefore, there is no question of holding an inquiry to find out whether offense is made out or not. I am issuing process straight away. I am issuing summons straight away. Now, there is an exception to this. Supposing the accused are residing in a place which is outside the territorial jurisdiction of the magistrate. Supposing the magistrate is sitting in Ahmedabad, he is in jurisdiction of, say, Naurangpura police station, or Gujarat, because this is an income tax offense, so he has the jurisdiction of Gujarat, say. But the accused is saying in Bombay, that is outside Gujarat territories. Then there is a provision in 202 which says, kindly read this. Any magistrate on receipt of a complaint of an offense of which is authorized to take cognizance or which has been made over to him under section 192 may, if he thinks fit, and shall in a case where the accused is, and this is important, and shall in a case where the accused is residing in a place beyond the area in which he exercises jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by a police officer or by such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding. So if the accused is residing at Mumbai he can move an application saying that the magistrate has not held this inquiry, which is mandatory. The Supreme Court has said that this inquiry is mandatory. He is required to follow this inquiry if the accused is residing outside the territorial jurisdiction of the magistrate. Therefore, you can ask the higher superior court, go to the superior court and say, this order whereby he has summoned me without holding an inquiry under section 202, which is a mandatory requirement of law. Therefore, kindly strike down the order. The order will be struck down. The order issuing summons will be struck down, and the matter will be remanded back to enable the magistrate to hold an inquiry. So when you get this order, you are not actually succeeded. You are only postponing the D-Day. Because again, the inquiry will be held and the magistrate will subsequently issue summons. Now come back to the next slide, please.
Mr. Parth will come back in 2 minutes. There is some technical issues. Sir, you request to kindly proceed.
Okay. There's one more ground which I missed, that is settlement commission. Settlement commission, if you apply to the settlement commission also, you can get the complaint. You can see that the complaint doesn't proceed further. Hello. Am I still there?
Yeah, sir. You are on. You are live,
Something
sir.
happened to the screen. Something happened to the screen, so I was wondering whether. So basically, as far as IT offenses are concerned, they are non-cognizable, bailable, and there is no arrest made. So all those persons, excepting for 274BB, which I said is a cognizable offense, one should not be much perturbed as far as getting anticipatory bail is concerned or getting regular bail is concerned. Now, as far as the other section which is missed out, which is not a non-cognizable offense, I will deal with it when I deal with the provisions of GST, but since the GST offenses are cognizable and non-bailable, what is the procedure required to be done? Now, these are the judgments. Go back one slide. These are the, no, you were there after that. Gosh, yes. No, one slide back, please. One slide, yes, that's it, hold it there. Now, if you look at these judgments, all these judgments lay down that if no offense is made out, then the complaint can be quashed. Then the accused is not required to undergo the agony of a trial. The first judgment is State of Haryana versus Bhajanlal. Citation is there. I hope you can see the citation. Second is Sunil Kumar versus Escorts. Third is K. Ramakrishna versus State of Bihar. Satish Mehra versus State. Varinder Singh versus State. Manik Taneja versus State. And Ramesh Raj Gopal versus Devi Polymers. So these are the few cases. There are a large number of cases, but these are the cases which have laid down that if no offense is made out, then the complaint goes home and you need not face a trial. Now come to the next slide, please. Now, if you look at the Income Tax Act, kindly have a look at the Income Tax Act. And you will see a provision of vicarious liabilities. That you will say which is section 278 capital B. Now, what is the provision? What do you mean by vicarious liability? ordinarily, a person who has committed the offense is required to face the trial. That is a general principle of criminal law. If I have not committed the offense, I am not required to face the offense or face the trial. Now, asking somebody to face the trial for an offense committed by somebody else is known as vicarious liability. So if offense is committed by X and Y is required to face the offense, then he is required. Then it is said that there is vicarious liability. Now, this principle of vicarious liability generally applies in cases of companies and partnership firms. Now, what happens if the offense is committed by a company or a partnership firm? The company is prosecuted, but along with the company, the managing director or director is also prosecuted. But if the managing director or the director has no role, he has nothing to do with the case, can he be prosecuted? And if he can be prosecuted, under what circumstances can he be prosecuted? All this is found in section 278 capital B of the Income Tax Act. So that section says that where an offense under the act has been committed by a company, every person who at the time of the offense was committed was in charge of and was responsible to the company for the conduct of the business of company, as well as the company, shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. So every person in charge of the business of the company or responsible for the conduct of the business of the company will be deemed to be guilty despite the fact that the offense has been committed by the company. Therefore, a director, though he has strictly not committed the offense, but since he was in charge of the conduct of the business of the company, he will be deemed to have committed the offense because he is vicariously held liable. This is one. The second is that if the offense is committed with the consent or connivance or is attributable to any neglect on the part of any director, manager, secretary, or other officer of the company, then also he'll be held responsible. Therefore, if you are neglectful and because of your neglect or because of your connivance, the offense is committed, then even though you have not directly committed the offense, you'll be still held to be vicariously liable. But you can show that I was not negligent, there was no connivance, in which case you will get out of the trial. But at the stage before the trial commences, what is the remedy as far as vicarious liability is concerned? See, earlier there were two views. The views were this. Some judgments of the Supreme Court took the view that for holding a director to be vicariously liable, there is no need for the company to be made an accused. So without making the company an accused, or without making the partnership firm as an accused, because partnership firm is also deemed to be a company for the purpose of this section, a director or a partner can be made an accused. That is what some judgments of the Supreme Court said. Some judgments took the view, no, it is not possible unless the principal offender, which is the company or the partnership firm, is made an accused. You cannot take in the secondary accused, that is the partner or director, and make him liable. So if the company is not made a director, then a company is not made an accused, then the director cannot be prosecuted. Those were the two views of the Supreme Court. Then in Anita Hada's case, the first case, 2012 5 SCC 661, the Supreme Court said, yes, it is required that the company should be made an accused. If the company is not made an accused, the director cannot be made an accused. The complaint goes home he cannot be prosecuted without the company being prosecuted with him. That is what Anita Hada's case said, and that is what the other cases which are also referred to is that the company has to be named an accused, has to be made an accused. Therefore, one of the grounds which you can raise in your quashing petition or in your petition, revision petition before the Sessions Court, is that the company is not made an accused. And therefore, if the company is not made an accused, the director cannot be made an accused because he is made an accused vicariously, therefore quash the complaint. So these are the lines of judgments which you can take note of and make an application saying that in a particular case, the company is not made an accused, the director can be prosecuted with. The partnership firm is not made an accused, therefore the partner cannot be prosecuted with. So these are the judgments. Then the second line of judgments as far as vicarious liability is concerned, the most famous being SMS Pharmaceuticals. In that case, the Supreme Court said, yes, the director or a managing director or an officer of the company can be made an accused, even if the company has committed the offense. But in that case, you have to make specific averments in the complaint, specifying the role of the director, specifying the role of the managing director, specifying the role of the partner, and if what you have specified is correct, and if it makes him vicariously liable, then only he can be proceeded with. Therefore, in many cases, the Supreme Court has quashed the complaints, stating that the averments in the complaint do not make out that this particular director can be held to be vicariously liable. So therefore, when the complaint is drafted by the income tax authorities, if there is a lacuna, and the lacuna is this, that it is not mentioned that the particular director is responsible for the conduct of the business of the company, or as to how he is responsible for the conduct of the business of the company, then the complaint with respect to that director can be quashed. Now, in SMS Pharma, which is a three-bench judgment of the Supreme Court, three judges judgment of the Supreme Court, the Supreme Court said that for managing director, there need not be such averments, because managing director, by virtue of the post, is deemed to be responsible for the conduct of the business of the company. Therefore, for other directors, you'll probably succeed. Therefore, this is a ground which you can raise before the High Court or before the Sessions Court and say that, look here, with respect to this particular accused, there is no offense made out. Then you come to so this is as far as the provisions of Income Tax Act are concerned, and pertaining to offences, pertaining to prosecution, pertaining and the remedies which I have suggested. There may be other specific remedies also. Now, there may be certain overlap when I come to the provisions of the GST. So when there's an overlap, I'll tell you what is the overlap. Now, GST is a new act, is a nascent legislation. Some people call it a virgin legislation because it come into force in 2017. You will not find only few case laws are there, but it makes interesting reading. Now, if you look at the GST Act, two provisions are very important or relevant as far as this topic is concerned. One is Section 69 and the other is Section 132. Now, Section 169 gives the power to arrest. So certain officers are conferred the powers to arrest for violation of certain provisions of the GST Act. As you have noticed that there is no such power conferred under the Income Tax Act. Under the Income Tax Act, no officer of the Income Tax Department has been conferred the power to arrest. The only exception is in recovery proceedings. In the tax recovery proceeding, the tax recovery officer for the purpose of recovery of tax, he can issue a warrant, get the person detained. He can also attach the properties. That person is detained in civil prison. But for the purpose of an offense under the Income Tax Act, there is no provision for arresting a person, unlike the GST Act. Now, under the GST, there are different types of offenses. And the power is conferred to arrest in three offenses. Actually, there are two. But the second is actually not an offense, it's a subsequent offense, but the nature of the offense is the same as the first one. So kindly have a look at section 69. Section 69 says, where the commissioner has reason to believe that a person has committed any offense. The important word is committed any offense. So he has to have material before him to show that a person has committed any offense. Merely on suspicion, that person can't be arrested. Therefore, there have been some cases on this aspect of committed any offense. I'll come to it when I deal with the case law. So kindly note the term committed any offense. So if he feels he reason to believe that any person has committed any offense, what type of offense? Offense specified in clause A, B, C, D of subsection 1 of 132. So they should be falling, that type of offense should be falling under clause A or clause B or clause C or clause D. That is the nature of the offense. And it should be punishable under subsection 1, clause small Roman 1 and clause small Roman 2 of subsection 1. And or subsection 2 of the said section. So what does that mean? Kindly go to the next slide. No, there is one slide which is missing. One slide, please. Earlier, you missed one slide. Yes, yes, the next one. Now, one more slide. Go ahead. Right. So this, what are these A, B, C, and D? I told you that he must commit an offense pertaining to clauses A, B, C, and D. Now, what are these A, B, and C? Whoever commits any of the following offenses, namely supplies any goods or services, or both without issue of invoices. So if goods are supplied without issue of invoices, then second is issues any invoice or bill without supply of goods, etc. Third is avails input tax credit. And fourth, collects any amount as tax but fails to pay to the government. These are the four clauses A, B, C, and D. Now go to the next clause, please. Next slide. Next slide. Yes. Now, if he commits any of those four offenses falling under A, B, C, D, and if the amount of tax evaded is more than 5 lakhs, then he falls under small Roman 1, and the punishment may extend to 5 years with fine. So if it falls under first small Roman 1, he can be arrested. The second is in cases where the amount of tax is evaded or amount of input tax is wrongly availed of, and the amount involved is between 2 crores and 5 crores, then he can be arrested. The punishment here is 3 years. So if the evasion is for more than 5 crores, it is 5 years. If it is between 2 crores and 5 crores, it is 3 years. If it is less than 2 crores, that is clause 3, with which you are not concerned, that is 1 year punishment. That is 1 year punishment. And if it abates, then it is 6 months. We are not concerned with 3 and 4, where it is 1 year punishment and 6 months punishment. We are concerned with 2 cases. The first case is where the evasion is of more than 5 crores, in which case the sentence is 5 years. In that case, the person can be arrested. That is what section 69 says. In the second case, if the evasion is between 2 crores and 5 crores, then that person can be arrested. That is what section 69 says, and that the punishment is 3 years. Okay. Now, come back to 132.2, subsection 2. Next, please. Next, please. Next. So this yes. Where any person is convicted of offense under this section is again convicted of an offense under this section, he shall be punishable for a second and subsequent offense with imprisonment which may extend to 5 years. So for a second offense also, and if the commissioner feels that the second offense is committed, then also he can be arrested. So analyzing this section 69 read with 132, what does it boil down to? It boils down to this, that for 5 years offense, he can be arrested. For 3 years offense, he can be arrested. And for subsequent offense, which is punishable with 5 years, he can be arrested. These are the 3 cases in which he can be arrested. Now kindly come to 132.4. Yes. Now it says that a person can be arrested for 3 types of offenses, which I said, 2 which are punishable with 5 years imprisonment, 1 which is punishable with 3 years imprisonment. Then subsection 4 says that notwithstanding anything contained in the Code of Criminal Procedure, all offenses under this Act, except offense referred to in subsection 5, shall be non-cognizable and bailable. So those 3 offenses which are referred to, excepting the offense referred to in subsection 5, all shall be non-cognizable and bailable. Now, what is that offense referred to in subsection 5? Kindly come to the next slide. The offenses specified in clauses A, B, C, and D of subsection 1 and punishable under clause 1, therefore punishable with 5 years, shall be cognizable and non-bailable. All other offenses shall be punishable as if it is a non-cognizable and bailable. Therefore, the first part, so 132.1 small Roman 1, if the offense falls under that head, then it is cognizable and non-bailable. Otherwise, it is non-cognizable and non-cognizable and bailable. Okay. So the second offense, so if you are arrested for an offense where the evasion is between 2 and 5 crores, it is a non-cognizable and non-bailable offense. There can't be an arrest. Even if they arrested, then he has to be enlarged on bail, even if the person is arrested. So the issue is that for the other offenses which are punishable with 5 years, only he can be arrested. Now let us assume there can be an argument which can be made. Come back to the schedule. Kindly come to the schedule. Next slide, please. Yes. Now, if you look at the schedule, 3 years offense is cognizable and magistrate triable. So somebody can argue that, sir, even if it is 3 years, so what? Because the schedule applies, it is a cognizable offense and it's a non-bailable offense and it's a magistrate triable offense. If you look at the second row of the schedule. Now, this second row of the schedule, even if it applies, it would be a non-cognizable offense and a bailable offense, because the Supreme Court has interpreted if punishable with imprisonment for 3 years in the Customs Act case and said that it is a non-cognizable offense. Now kindly come to the next slide, please. If you look at section 135 of the Customs Act, small Roman 2, the word used was in any other case with imprisonment for a term which may extend to 3 years or with fine or with both, which is similar to our clause 2 of 132. Come to the next case, please. So in Avinash Bhosle's case, 2007-14 SCC 325, the Honorable Supreme Court said that 135(1)(2) of the Customs Act is bailable. And therefore, as far as 132 is concerned, second part of 132, where it is punishable with 3 years, would be bailable even if CRPC applies, even if CRPC doesn't apply, because of subsection 4 and subsection 5 of 132 of the GST. Now kindly if it is a bailable offense, what is this scenario? Yes. Bailable offenses are dealt with by section 436 of the CRPC. In a bailable offense, you are entitled to bail as a matter of fact You have an indefensible right to get bail. Bail can't be denied, excepting when you're not giving bail. Supposing you say, I don't have a surety, I will not give bail, I will not execute a bond, then only it can be refused. Otherwise, you're entitled to bail in all bailable offences as a matter of right. There is no, even immediately on arrest, the police are supposed to enlarge you on bail. The magistrate can't take you on remand, can't send you on police custody, can't send you on departmental custody if it is a bailable offence. So in Rasiklal's case, the Honorable Supreme Court in Para 10 has said that the position of persons accused of non-bailable offences is entirely different. The right to claim bail granted by Section 436 of the Code in a bailable offence is an absolute and indefeasible right. In bailable offences, there is no question of discretion in granting bail, as the words of Section 436 are imperative. The bail will be given to you if you are arrested for the offence punishable under the second part of 132, that is where the imprisonment of 3 years. So these are the cases where you can be arrested. Now we come to the remedies. What are the remedies you have? Now before I come to that, there's one thing which I forgot. There is no anti-bail for bailable offences. The provision pertaining to anticipatory bail is contained in Section 438 of the CRPC. And 438 of the CRPC says that only if you have an apprehension of being arrested in a non-bailable offence that you can move for anticipatory bail. So if your apprehension is that you are going to be arrested for a bailable offence, you can't move for anticipatory bail. Because the moment you're arrested, you're entitled to bail. So where's the question of going for anticipatory bail? Come to the next slide, please. So what are the remedies? As far as arrest is concerned, what options you have to avoid arrest? Legally avoid arrest. What are the options? Now the options are, first is anticipatory bail under Section 438 of the CRPC. The second is filing a writ petition under Article 226 of the Constitution. In Uttar Pradesh, prior to a few years where Section 438 was not there, then you had to file only a writ petition under 226 because there was no anticipatory bail in Uttar Pradesh. But in Gujarat, you have two options. One is you can file an application for anticipatory bail under Section 438 of the CRPC. And second is you can file a writ petition under Article 226 of the Constitution. Now come to the next slide. Now when you move for anticipatory bail in a GST offense, there is no FIR registered. The officers come and arrest you because the commissioner has ordered them. He comes and arrests you, or he threatens to arrest you. So when you go to a lawyer, ordinary lawyer will ask you, where is the FIR? Under which FIR they're wanting to arrest you? There is no FIR. Therefore, FIR is not required for applying for anticipatory bail. You can move for anticipatory bail even without an FIR. Because in all these cases, they file complaints, they do not file FIRs. Now, FIR is not required. These are the three cases of the Supreme Court which I've given. One is Gurbakh Singh CPS case, 5 judges constitutional bench, 1980, volume 2, SCC 565. Directorate of Enforcement versus Deepak Mahajan, 94, 3 SCC 440. And Sidram Matre, 2011, 1 SCC 694. Now, what happens when you file an anticipatory bail application? On what grounds can your anticipatory bail application be allowed? And on what grounds your anticipatory bail application will be rejected? General principles are that if the opposite party makes out a case for custody or custodial interrogation, then ordinarily anticipatory bail is not granted. So they can make out a case saying that, sir, there are a large number of documents which are to be recovered. He has kept these documents elsewhere. We have to recover these documents. We have to make, therefore, custodial interrogation is required. Then the court may not grant anticipatory bail. Gujarat High Court in 2 cases has held that if a person is ultimately going to get regular bail, then he should ordinarily be granted anticipatory bail. If ultimately he is going to be granted regular bail, then there is no harm in granting him anticipatory bail. Then I will show you when I come to regular bail, why ordinarily regular bail is to be granted in cases of this type. What is the principle for grant of regular bail? I'll deal with it a little later. But I must tell you that as far as my experience is concerned, when it comes to evasion of huge taxes, the stock argument is an economic offense against the country. Therefore, you should not grant bail or ask him to deposit some money, etc. So that those arguments are there. Sometimes many courts are carried away by these arguments. So strict, and there is a discretion as far as grant of anticipatory bail is concerned. Therefore, you may or may not get anticipatory bail, but it all depends on the court and the type of case that is made out against your client. Then come to the next slide, please. Now, most of the petitions which are filed under Article 226 of the Constitution are relying on the wordings of Section 69. Kindly come back to Section 69. Section 69 says, yes, where the commissioner has reason to believe that the person has committed any offense. So many judgments have taken the view that committed any offense. When can you say a person has committed an offense? Merely because you apprehend is not sufficient. There has to be something concrete. There need not be a final adjudication, or if I may use the words of the Income Tax Act, final assessment. But there has to be something concrete. Merely on allegations, the person cannot be arrested. If there are mere allegations, then he can't. There has to be something substantial for the commissioner to come to a conclusion or have reason to believe that the person has committed an offense. Therefore, 226 petitions are filed in the High Court saying that, sir, he's going to arrest me, but there is no reason to believe that I've committed offense. There is nothing concrete, there is nothing substantial with him to come to that conclusion. Now, the first case which comes to my mind is that of Vimal Yashwant Giri Goswami. Come back there. Back, please. Next. Yes. In Vimal Yashwant Giri Goswami's case, the Gujarat High Court, Division Bench of the Gujarat High Court, passed an interim order consisting of Justice Pardiwala and Justice Rao, passed an interim order saying that no coercive action to be taken. But at the time of passing of this interim order, which is still in force, they said that there has to be something concrete for passing an order of arrest. And they relied on this section 69, and particularly the words committing, has committed an offense, and certain judgments of the other courts. Come to the next slide, please. So this is what the Gujarat High Court held. To put it in other words, the power of arrest under Section 69 of the Act 2007 are to be exercised with a lot of care and circumspection. Prosecution should normally be launched only after the adjudication is completed. That is with respect to prosecution. To put it in other words, there must be in the first place a determination that a person is liable to penalty. Till that point of time, the entire case proceeds on the basis that there must be an apprehended evasion of tax by the SSC. In the 2 decisions referred to above, emphasis has been laid on the safeguards as enshrined under the Constitution of India, and in particular, Article 22, which pertains to arrest, and Article 21, which mandates that no person shall be deprived of his life and liberty for the authority of law. The 2 high courts have extensively relied upon the decision of the Supreme Court in D.K. Basu's case. Then kindly let notice be issued to the respondent returnable on so and so. In the meantime, no coercive steps of arrest shall be taken against the writ applicant. Now, what are the 2 cases that the Gujarat High Court relied upon? In this case, one is Make My Trip Private Limited versus Union of India. That is 2016-14 STR 481. This is an extensive, well-written judgment, and it went to the Supreme Court. Supreme Court dismissed the SLP, saying that we agree with the reasoning of the High Court, and what the High Court has said is correct. It was strictly not under the GST, but it was under the Finance Act, but the provisions are similar. And in Jayachandran Ella's case also, the Madras High Court, following Make My Trip, etc., has taken the same view. In Akhil Krishnan Maggu, also the same view has been taken. So you have a chance to apply to the High Court and saying, sir, how can they arrest me now? There is no determination that I've committed an offense. Prima facie, at least he must hold that I've committed offense. Merely on ipsi dixi, merely on some conjecture, merely on surmises, he can't be arrested. Therefore, in many cases, the High Courts interfere under Article 226 and pass orders of no coercive action, which is as good as getting anticipatory bail. Now, there is one judgment which I must, the other judgment is EBIS, etc. also. Now, before I come to Telangana judgment, which I must deal with, because Telangana has taken a slightly different view. And I'll tell you why the Telangana judgment is wrong. Now, there is another requirement as to whether Section 41 of the CRPC is to be followed. Now, if you look at Section 41 of the CRPC, it takes into consideration what the Supreme Court has said in number of judgments, that a person should not ordinarily be arrested. There has to be reason why he has to be arrested. The police officer must record his reasons, etc. So in Arnesh Kumar, the Supreme Court said that all offences punishable with 7 years, Section 41 has to be applied, and the observation made in Arnesh Kumar is to be applied. Though Arnesh Kumar was a case pertaining to a matrimonial offence, the Supreme Court said no. For all offences punishable with 7 years, these principles which we have laid down will apply. Therefore, the second ground which is available to you is to challenge and say that they have not followed the principles laid down in Arnesh Kumar. I'll only read one paragraph for Arnesh Kumar because I'm running short of time. Para 6. Law commissions, police commissions, and this court in large number of judgments emphasize the need to maintain a balance between individual liberty and societal order while exercising the power of arrest. Police officers make arrest as they believe that they possess the power to do so. So this will apply even for department arrest. As arrest curtails freedom, brings humiliation and casts scars forever, we feel differently. We believe that no arrest should be made only because the offense is non-bailable and cognizable, and therefore lawful for the police officers to do so. The existence of the power to arrest is one thing. The justification for the exercise is quite another. Apart from the power to arrest, the police officers must be liable to justify the reasons. Therefore, no arrest can be made in a routine manner or a mere allegation of commission offense made against a person. It would be prudent and wise for a police officer that no arrest is made without a reasonable satisfaction raised after some investigation as to the genuineness of the allegation. Despite this legal position, the legislature did not file any improvement. Number of arrests have not decreased. Ultimately, Parliament had to intervene on the recommendation of the 17th report of Law Commission submitted in the year that Section 41 of the Code of Criminal Procedure in the present form came to be enacted. Now come to the next slide, please. So Supreme Court says that Section 41 has to be followed. There are certain safeguards under Section 41 of the CRPC. Now whether Section 41 applies to the GST or not. The Punjab and Haryana High Court in Akhil Krishnan Maggu says that it applies. Even the Telangana judgment doesn't say it does not apply. It says it may apply. Telangana judgment is one judgment which is cited by the prosecutor whenever he opposes your application of the GST. Now, as far as these two judgments are concerned, the main contention was that they are not the departmental officers who are making the arrest are not police officers. Section 41 applies to police officers. But that has been brushed aside even in Telangana's judgment, because ultimately the principle is that constitutional rights are offended by an arrest. So whether a police officer makes an arrest or whether a departmental officer makes an arrest does not make any difference. Now come to the next slide, please. I have extracted section 41 of the CRPC, which says when a police may arrest without warrant. Now go to the, come back, sorry. Come back, please. Any police officer may, without an order of the magistrate, without orders, arrest any person who commits in the presence of police or cognizant offence against whom a reasonable complaint of credible information is received or a reasonable suspicion exists that he has committed cognizant offence, punishable imprisonment for a term which may be less than 7 years or it may extend to 7 years, whether or with fund in the if the following conditions are satisfied. Come to the next slide. So those conditions are, what are those conditions? The police officer reason to believe on the basis of such complaint, information or suspicion that such person has committed the said offence, which is similar to section 69 of GST. Second is the police officer is satisfied that such arrest is necessary to prevent such person from committing any further offence, proper investigation of the offence, prevent such person from causing evidence of the offence to disappear, etc. So these are the cases where he can arrest, but he must record in writing why he is making such arrest. So these are the safeguards which are given under section 41, which the Supreme Court says has to be followed. There has to be some investigation, etc. done, and these safeguards are to be followed. Now I'll tell you why the Telangana judgment is wrong. Because this Telangana judgment come back to the next slide, please. This Telangana judgment is okay. Now, before I come to the Telangana judgment, let me deal with the principles as far as ordinary bail is concerned. What happens if an accused is arrested? Once he is arrested, there is no question of anticipatory bail. Because anticipatory bail is pre-arrest. The stage of operation of anticipatory bail is pre-arrest. So once you are arrested, your application for anticipatory bail becomes infructuous. So a person who is arrested cannot move for anticipatory bail. Then you have to move for regular bail. Regular bail, you move under section 439 of the CRPC. Or if it is before a magistrate, it is moved under section 437 of the CRPC. So you can move before the magistrate under section 439 of the CRPC. You can move before the Sessions Court or the High Court under 439 of the CRPC. So after a person is arrested, you have to move for regular bail. Now, if you move for regular bail, what is the principle and can you get bail? Now, the test, the most important test, whether a person is to be granted bail or not, the most important requirement is what is the severity of the offense. How severe is the offense? If the offense is severe, then ordinarily bail is not to be granted. So how do you determine that the offense is severe or not severe? Is there a yardstick to find out that this is a severe offense, this is a very harsh offense, therefore no bail is to be granted? Or is it on the whims and caprice of a judge? The judge will say, oh, I feel that this offense is harsh because I did not have tea in the morning. No, that is not so. The test is punishment. The courts have laid down that the legislature, in its wisdom, has prescribed punishment for an offense. If the offense is strict, if the offense is severe, then the punishment will be more. If the offense is not that severe, the punishment would be less. So the yardstick to determine whether the offense is severe or not is the punishment prescribed for that offense. So ordinarily, offenses punishable with imprisonment for life or imprisonment with death are treated as offenses which are severe, for which ordinarily bail is not to be granted. That you will find in the wordings of section 437 also. But the most important case is the case of Gurcharan Singh versus State, which is extracted above. Now, in Gurcharan Singh's case, the Supreme Court, while interpreting Section 437 of the CRPC, classified offences into two categories. One, they said, punishable with imprisonment for life or death. And second, they said, all such offences which are not punishable with imprisonment for life or death. In the first category, they said, no bail is to be granted ordinarily. In the second case, they said, bail is a matter of right, unless he's tampering with evidence or likely to abscond, etc. Now, that classic judgment, you'll find these observations in para 22 of this judgment. Kindly see that judgment. In other non-bailable cases, other means those non-bailable cases where the punishment is not life or death. In other non-bailable cases, the court will exercise the judicial discretion in favor of granting bail, subject to subsection 3 of 437 CRPC. What is 437(3)? It is laying of conditions, if it deems necessary to act under it. Now, what follows is very important. Unless exceptional circumstances are brought to the notice of the court which may defeat proper investigation of fair trial, the court will not decline to grant bail to a person who is not accused of offence punishable with death or imprisonment life. It is also clear that when accused is brought before the court of magistrate with the allegation against him of an offence punishable with death or imprisonment life, he has ordinarily no option in the matter but to refuse bail subject. However, the first provision so and in a case where the magistrate entered, that is a different thing. This is, however, been extra. That is where life and death is there. But the Supreme Court has said this categorically, that if the accused is not punishable with, is not accused of offence punishable with life or death, ordinarily bail is to be granted. Court will not decline to grant bail to such a person. Now come to the next slide. This is next slide, please. You have that. Yes, Sanjay Chandra. Now, Sanjay Chandra is the 2G case. Now, in this 2G case, it was an economic offense running into thousands of crores. One of the arguments put forth was, sir, how can you grant bail to a person accused of a scam of few thousand crores? This is an economic offense. Economic offense is even more dangerous than murder. Now look at how Supreme Court has dealt with it, because they have gone by the yardstick of punishment as held in Gurcharan Singh's case, which I just read. They have said, coming back to the facts of the present case, both the courts have refused the request for grant of bail on two grounds. The primary ground is that the offense alleged against the accused person is very serious, involving deep-rooted planning in which huge financial loss is caused to the state exchequer. The secondary ground is that the possibility of accused person tampering with the witnesses. In the present case, the charge is of that of cheating and dishonestly inducing delivery of property and forgery for the purpose of cheating, using as genuine a fraud document. The punishment for the offense is imprisonment for a term which may extend to 7 years. It is no doubt true the nature of charge may be relevant, but at the same time, the punishment to which the party may be liable if convicted also bears upon the issue. Therefore, in determining whether to grant bail, both the seriousness of the charge and severity of the punishment should be taken into consideration. In our case, in GST, it is 5 years. Here it was 7 years in a scam of 2,000 crores. So the principle is severity of the offense has to be looked out, and the yardstick is, as far as severity is concerned, the quantum of punishment. And therefore, ordinarily, bail is to be granted. There are a number of cases where bail has been granted, some cases even without deposit of any money. Shall we curtail this and go to the question, because it's already 5:30?
So what we
Yes,
may,
Parth.
subject to what you suggest, you may continue with the lecture and complete it. We will invite questions over email and have it sent across to you, or you may want to take question answers. We can open it to questions.
I'll take question answers now, because I've got a conference a little later, and I've got a video conference at about 6. So it's better that I take the question.
We'll take about 4 or 5 questions, sir.
Okay, go ahead.
So one question that we are getting is, in GST cases, in a lot of instances where arrests are made, FIRs are filed in a very hasty manner, and then subsequently in some instances supplementary FIRs are being filed. Is a supplementary FIR maintainable in law?
Are you talking of supplementary FIRs or complaints? Usually the complaints are being filed. I have yet not come across a case where FIR has been filed.
Complaints. And so the query must be complaints.
Now, Supreme Court has said, I don't recall, but recently they have said that if it doesn't go to the, it is not something which changes the nature of the case, you can also file a supplementary complaint. You can make an amendment to a complaint. Now, I'll tell you what, it all depends on many things. The issue is whether it is, just give me just a minute. The issue is whether it is to be treated as a supplementary complaint or whether it is to be treated as additional evidence is being produced. Now, supposing the first complaint is filed and something subsequently is found out. Say something subsequently can be in the nature of two things. One, it can be additional evidence, or second, it can be that some other offense has been committed. If some other offense has been committed, which was not discovered at the time when the first complaint was filed, you can file a second complaint. There's no bar to filing of a second complaint. Now, as far as additional evidence is concerned, you can always produce an additional evidence. There is no need to file a subsequent complaint. Now, in the particular case, you'll have to tell me why that subsequent complaint has been filed. What is there in that subsequent complaint? Because unless you give me those particulars, it will not be possible for me to answer to the query. You can tell me that complaint is filed because of this reason, and subsequent complaint has been filed because of this reason. Then I'll be able to answer the question more precisely. But otherwise, it will be a vague answer to a vague question.
So the other queries, one of the queries that a government contractor or a government entity deducted TDS, but failed to make payment and produce a TDS certificate. In such an instance, can a private party who's the contractor file a police complaint or approach the income tax department to file a police complaint against such government PSU or a government entity?
Now, if you look at the provisions, this is as far as the Income Tax Act is concerned,
yes,
right?
Yes.
Now, if you look at the Income Tax Act, kindly look at the Income Tax Act. And kindly look at section 279. If you look at 279, prosecution to be at the instance of chief commissioner or principal commissioner of so-and-so. So it has to be, and as far as the sanction is concerned, sanction is required. Without sanction, it can't be filed. Now you remember Prevention of Corruption Act. And the Prevention of Corruption Act, ordinarily complaint is filed by the police, the trap laying officer, it's a bribe, etc. But there was a trend which started probably from Antule's case, where private complaints was filed, Ramdas filed private complaint against Antule, if you recollect. Now, Supreme Court has recently held in a Prevention of Corruption Act case that there can't be investigation on a private complaint without a sanction. So if that logic is applied, and if you cite that judgment, which will be applicable here also, because here also sanction is required. So without sanction, that private complaint cannot be filed, and that you can take recourse to that judgment under the Prevention of Corruption Act. I can give that citation, but I don't have it offhand right now.
So generally what happens is once a person is arrested, there are conditions attached to his bail. Now after the arrest, there is an instance where a show cause notice is filed, or a show cause notice is issued by the concerned authority to the assessee.
Yes.
Should the conditions attached to the bail continue till the show cause notice is issued, or it should ideally continue much beyond until an order of adjudication is passed?
See, again, it depends on nature of condition. Now, usually what are the conditions which are given to bail? One is that surety. That surety condition will endure till the trial is over. So that condition cannot change. The second condition is that generally that he has to deposit a passport, or that he should not leave India without the permission of the court. Now, what is the type of condition? There may be a condition which sometimes they say you don't have to enter into, say, in criminal offenses, they'll say don't enter into, say, limits of Ahmedabad city. That type of condition cannot endure forever. That type of condition you can change. But what is the type of condition that you want to? But I'll tell you one thing. I had argued and succeeded before Justice Zaveri, where I said that conditions can be imposed only if the offense is punishable with 7 years of imprisonment. Otherwise, no condition can be imposed. If you look at section 437 of the CRPC, kindly have a look at section 437 of the CRPC. There you will find that only if the offense is punishable with 7 years imprisonment, a court is empowered to put conditions. If you look at section 437 of the CRPC, and it says, subsection 3, where a person accused or suspected of the commission of offense punishable with imprisonment which may extend 7 years or more, or offense under chapter so and so, the court shall impose the conditions. Therefore, the power to impose conditions is only when the offense is punishable with 7 years. So I argued and succeeded. Probably you can take up that argument and say that you don't have a power to impose condition. Depends on what is the nature of condition.
So is mens rea mandatory in all evasion cases?
There is a presumption that there is a mens rea. Therefore it becomes. Otherwise, where is the question of the presumption being there? It may not be necessary, but there's a presumption that there is mens rea. Therefore, there's a presumption unless you rebut that if it is not, if your offense is committed and mens rea is not required, then it may have a bearing on the sentence. But there is a presumption that there is a mens rea, unless you rebut that presumption.
Correct. So, in an offense under either registered for offenses under the GST or the Income Tax Act, can it automatically or can it lead to triggering of the provisions under the PMLA Act also?
It depends whether it is a scheduled offense or not.
So we'll take one last question. Whether prosecution can be initiated only after adjudication or even prior thereto?
Can you come back? There was a sorry.
Whether prosecution can be initiated only after adjudication or even prior thereto?
That has now been settled by Radheram. What is that case? Ram Kishan Kejriwal's case. Kindly come to that case. I'll give its answer. There's no requirement. They can go simultaneously. That is what the Supreme Court has held. Just give me a minute. I'll give you that judgment. Adjudication. There were issues under the Income Tax Act where they said that assessment kindly stay it. So the issue was whether it should be stayed or not. But the High Courts and all the courts have held following this Ram Kishan Kejriwal's case. I'll tell you what it is. Now, just this is a judgment. In Radhesham Kejriwal's case, right?
Yes.
Which is referred to in para 76 of Make My Trip India Private Limited, the Supreme Court by 2-1 majority said in Standard Chartered Bank, GL Didwani, etc., adjudication proceedings and criminal proceedings can be launched simultaneously. Distance in adjudication proceedings is not necessary before initiating criminal prosecution. Adjudication proceedings and criminal proceedings are independent in nature to each other. But this is what the Supreme Court has said.
Thank you so much, sir. I think we'll put an end to the question answer session. Thank you so much for sparing time for all of us here.
No, thank you very much. I must also thank a few of my juniors who had helped me, because I was totally, and there is no staff, there are no juniors, there's nobody, I'm alone in the office. yet a number of my juniors, if you may permit me, I may give their names. One is Rajesh Goswami, Chetan Pandya, then Dhruv Tolia, Nimit Shukla, and Shaishav Pandit, Bhatrish Raju, Sairika Raju. All of them helped because I am new to this PowerPoint presentation and all that. So they all helped me. They all gave me compilation of case law, and I hope I have met your standards, which is required.
We've
Thank
had a
you.
fantastic session today. Thank you so much. This is one issue which is always an area of concern for most of the tax consultants and tax practitioners as far as assessees are concerned. So thank you so much for sparing time for all of us. Tomorrow we have another fantastic session where Senior Advocate Mr. Nakul Diwan will be taking us through the issues of commercial litigations vis-a-vis the Constitution. We'll see you all again tomorrow at 4 o'clock for the session tomorrow. Thank you so much. Thank you, HPFTC and all other associations for being a part of this. Thank you.
Thank you.
Thank you, sir.
Bye-bye.
Thank you, sir.
Thank you, sir.
Thank you. Bye-bye.